will stand part. We now come to debate on Part 4. This is clauses 117 to 146 and Schedule 4. The question is that Part 4 stand part. Members, the question is that Part 4 stand... Carmel Sepuloni.
Speaking to Part 4, Mr Chair, I have to just start off. I want to speak to this bill, but I just also have to acknowledge that I'm a newbie on the Select Committee. I do have some questions, but I'm not going to pretend that I'm an expert like my colleague Charles Cheval or David Parker on this particular issue. Before I get into Part 4, Mr Speaker, I do just need to say that Labor believes reforms are necessary with an emphasis on the public defender system, community law centres and focus on quality assurance. However, we have concerns about this bill and the government's overall direction with regards to its justice policy, which seem to be inhibiting access to justice, Mr Chair. So, just getting on to Part 4. So transitional and savings provisions, amendments to other enactments and repeals. Transitional arrangements for transfer of legal services agency to Ministry of Justice. So what we see here, Mr Chair, is that legal services agency will no longer exist. Public Advisory Committee is disestablished. Assets and liabilities of the agency will be transferred to the Ministry of Justice. Employees of the agency will be transferred to the Ministry unless they do not consent. The terms and conditions of the employment cannot be any less favourable. Transition of matters, legal aid granted by the old Act is not affected by the enactment of the new Act. Some of the non-legislative changes that we see in here as well as the changes outlined previously, the government has agreed to expand the public defence service to Hamilton, Wellington and Christchurch and work with community law centres to develop a uniform set out standards. With regards to the public defence service, so we see that the Public Defence Service was launched by then Justice Minister Phil Goff at Auckland at Manukau Courts in 2004 as a 5-year pilot, and in August last year the LSA made it permanent. The Public Defence Service has its origins in Labour's 1999 manifesto, which I think is important to point out. There have been 2 independent evaluations of the service. Both found it offers savings in lawyer costs when compared to the estimated cost of equivalent private providers, a saving of $985,000 over the period of the pilot. These savings were achieved with no difference in outcome for the client as measured by overall conviction rates. Simon Power announced in April that the public defence services will be expanded to Hamilton, Wellington and Christchurch. Now, Mr Chair, I just want to turn to the Baisley report. So in April 2009, Justice Minister Simon Power appointed a panel chaired by Dame Margaret Baisley to review the legal aid system. And Dame Margaret produced a discussion document in September last year which outlined some concerns, and then a final report in November of last year called Transforming the Legal Aid System. The report was damning and prompted the government to announce an overhaul of the legal aid system. Now, what were the findings of that review? Variable quality legal aid services, including a number of lawyers who are poor performers and some who are alleged to be acting in a corrupt way. Dame Margaret found that around 200 lawyers are apparently rorting the system. Some practitioners pay backhanders to duty solicitors who recommend legal aid applicants to them. Some practitioners demand top-up payments from clients over and above the remuneration they receive from the Legal Services Agency. Complaints to the Law Society of dishonest behaviour were not acted on. Lawyers and defendants collude to make sure cases such as take as long as possible, a mutually beneficial arrangement under which the lawyer racks up fees and the defendant delays conviction and sentencing. I'm just kind of going through the findings of the review here. The quality of legal aid lawyers is variable, and many of them show up at court unprepared or late, and some lawyers game the system apparently by delaying a plea or changing pleas partway through the process in order to maximise legal aid payments. Specifically, Dame Margaret was told up to 80% of lawyers practising at Manukau District Court could be gaming the system. So this is what she was told. I'd really like to hear the Minister's thoughts on that. particularly in relation to what is being proposed in Part 4 of the legislation. A lot of the questions that I actually had were actually around Part 3, but that went biased as we moved on to Part 4 now. So I think I would just like to also just point out, I'll leave it at that, Mr Chair.
Can I just remind members, we are on Part 4, which is a pretty narrow debate. It's not a peroration of the review of the... So I just remind...
Good word.
Now, are you seeking the call?
Mr Chair.
Carol Beaumont.